Hello and welcome to the Minimum Competence episode for Thursday, June 20th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover accounting firms pushing back on stricter reporting rules, big tech's shift to on-device AI for privacy, families urging a $24 billion fine against Boeing for 737 MAX crashes, and the Supreme Court issues a decision in more. Let's remember, today is Thursday, otherwise known as Friday Eve, and read today's legal news. On this day in legal history, June 20th, 1893, in New Bedford, Massachusetts, Lizzie Borden was acquitted of the notorious axe murders of her father, Andrew Borden, and stepmother, Abby Borden. The trial had gripped the nation with its sensational details and the prominent social standing of the Borden family. On the morning of August 4th, 1892, Andrew and Abby were found brutally slain in their Fall River home, each having suffered multiple axe wounds. Lizzie, the prime suspect, was arrested and charged with their murders. The prosecution presented circumstantial evidence, including Lizzie's alleged attempts to purchase prussic acid, her burning of a dress similar to the one she was seen wearing on the day of the murders, and conflicting statements about her whereabouts. Despite this, the defense argued that there was no physical evidence directly linking Lizzie to the crime, and her reputation as a church-going, unmarried woman was emphasized to cast doubt on her guilt. The jury deliberated for less than 2 hours before returning a verdict of not guilty. Lizzie Borden's acquittal remains one of the most controversial and debated decisions in American legal history. The case has inspired numerous books, films, and even a popular rhyme embedding Lizzie Borden in American folklore. The legal proceedings highlighted the limitations of forensic science at the time and underscored the significant role of societal perceptions in the courtroom. U.S. accounting firms are pushing back against proposals for stricter reporting rules on their finances, operations, and audit performance, labeling them as overly rigid and costly. They prefer to keep reporting major business changes and financial results as part of routine inspections to protect sensitive information. Firms advocate for voluntary transparency reports over standardized forms for discussing audit management and staffing. The Public Company Accounting Oversight Board introduced draft rules in April, requiring firms to submit formal financial statements, details on ownership and governance, and business changes. These rules aim to meet investor demands for more auditor insights and codify existing practices, as firms already provide significant details to PCAOB inspections. Firms, structured as private partnerships, oppose adhering to U.S. GAAP or international standards for compelling their financial statements, arguing it would divert resources for an unnecessary set of records. They also question the PCAOB's authority under the Sarbanes-Oxley Act to demand such detailed disclosures. While the PCAOB's investor advisory group supports making these financial statements public and audited, audit firms argue this could compromise audit quality and mislead investors due to varying client portfolios. Progressive organizations and labor unions back the proposal, emphasizing that detailed reporting would enhance competition and audit quality. Big tech is shifting artificial intelligence from the cloud to users' personal devices, aiming to enhance privacy and performance. Apple introduced Apple Intelligence, a generative AI assistant that operates directly on devices, claiming it sets new privacy standards. Microsoft followed with Copilot Plus PCs, which include locally running AI models. This move, supported by Qualcomm, highlights the trend of on-device processing, which reduces latency, cost, and privacy concerns associated with cloud-based solutions. On-device AI aims to protect user data by keeping it on personal devices, thus eliminating risks associated with transmitting data to and from the cloud. However, challenges remain, such as ensuring these local models do not expose sensitive data or produce inaccurate outputs. Experts caution that while on-device AI enhances privacy, it does not eliminate all risks. The approach is particularly appealing to organizations handling confidential information. Running AI locally means data stays on the device, reducing the risk of exposure during transmission. Despite these benefits, core privacy challenges persist, especially in automated decision-making scenarios like HR processes. Companies must address the cybersecurity implications of hosting substantial data locally. Tech providers, including Apple and NVIDIA, note that running AI on devices involves trade-offs primarily related to the size and capability of models. Large models like OpenAI's GPT-4 are too big for individual devices, requiring compression techniques that might limit their functionality. Consequently, some complex tasks may still need cloud support. The shift to on-device AI represents a significant change from the cloud-centric trend of recent years. Organizations adopting this hybrid approach must adapt their AI governance, ensuring they understand and manage the new dynamics of data processing and security on personal devices. On June 19th, relatives of victims from 2 fatal Boeing 737 MAX crashes urged the U.S. Justice Department to impose a fine of up to $24.78 billion on Boeing and pursue criminal prosecution. The crashes in 2018 and 2019 resulted in 346 deaths, making it one of the deadliest corporate crimes in U.S. history, according to lawyer Paul Castle, speaking to Reuters. The family suggested suspending $14 billion to $22 billion of the fine if Boeing allocates those funds to an independent corporate monitor and compliance improvements. The Justice Department had previously determined that Boeing violated a 2021 deferred prosecution agreement, which shielded the company from a conspiracy to commit fraud charge related to the crashes. Despite Boeing's claim that it did not violate the agreement, federal prosecutors must decide by July 7th whether to proceed with a criminal case or negotiate a plea deal. An extension of the deferred prosecution agreement is also an option. The violation was confirmed after an incident involving an Alaska Airlines Boeing 737 MAX 9 on January 5th, exposing ongoing safety and quality issues at Boeing. The families also called for Boeing's board of directors to meet with them and for criminal prosecutions of corporate officials responsible at the time of the crashes. Senator Richard Blumenthal, chair of the Senate's Permanent Subcommittee on Investigations, supported the call for prosecution, citing overwhelming evidence. The two crashes, linked to a safety system called MCAS, led to a 20-month worldwide grounding of the Boeing 737 MAX. In the case of Moore v. United States, the Supreme Court ruled 7-2 today that the mandatory repatriation tax, part of the Tax Cuts and Jobs Act of 2017, does not violate the Constitution's direct tax clause. This tax requires U.S. shareholders of foreign corporations to pay taxes on their share of corporations' undistributed earnings. The court's decision provided temporary relief to tax practitioners by maintaining the status quo, but the broader implications of this decision are yet to be seen, particularly in light of the pending Loper-Bright Enterprises v. Raimondo case. Loper-Bright challenges the so-called Chevron deference, which we've talked about on this show, a doctrine that requires courts to defer to an administrative agency's reasonable interpretation of an ambiguous statute. This case questions whether statutory silence implies statutory ambiguity, specifically in the context of the National Marine Fishery Services regulations. The Supreme Court's conservative majority could potentially use this case to limit or overturn Chevron deference, which has been a cornerstone of administrative law for decades. The Moore decision emphasized that Congress can tax U.S. shareholders on the income of foreign corporations, affirming the current tax framework. However, the potential outcome of Loper-Bright could significantly disrupt administrative law, including tax regulations. Without Chevron deference, courts might no longer defer to the IRS's interpretations of complex tax statutes, leading to increased legal challenges and uncertainty in tax regulation. Thus, while the Moore case today offers short-term stability, the legal community is now closely watching Loper-Bright for potential profound changes to administrative law and tax policy. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, it's not the load that breaks you down, it's the way you carry it.